over the past 5 years, just 4% of over 5,000 reported child abuse cases reported to the Teddy Bear Foundation have resulted in convictions. Now, this has highlighted serious concerns in the system as some activists call for more to be done to secure justice for victims as well as survivors. Let's now speak to Head of Advocacy for Women and Men Against Child Abuse, Luke Lamprecht. Luke, good evening to you and thank you so much for your time. Certainly, this figure is quite disturbing, and it's not the first time we see it, but the fact that, we haven't seen movement in that particular regard is disturbing.
It is indeed disturbing because I think the first thing is that, the President in his 5-point GBV plan called for a victim-centric approach to criminal justice as one of the 5 points in the plan. And, if you're having a conviction rate of 4%, that really just means that the victims' voices are being heard probably 4% of the time. What needs to be taken into consideration as well is that if you look at a set time period, we have the issue of if you're following up, some of the cases are still in court 7 years later. So you won't be recording a conviction because of the level of delays in the case. And then you have to look at the top of the filter, which is how many cases are actually reported. So if you look at the 4% as a percentage of cases that went to court, that's a fraction of the amount of cases that are occurring to children, and probably a fraction of those being reported that never end up in court.
And when you look at those who end up in court, right, the cases that end up before a magistrate or even a judge, how much of what we're seeing as far as the low conviction rate is concerned are as a result of possible delays or even postponements that we see?
There's definitely an issue with delays. So the first issue with delays, as I said, is that I've got a case in one of our magistrates' courts in the Greater Johannesburg. The child started her court case at 7. She's now 14. The case is still not finished. So while the case is not finished, we don't know if we're going to get a conviction, but that would be seen as not a conviction because it hasn't been finalized. And I mean, that's half that child's life. And the emotional and developmental impact on that child and family are absolutely devastating. So that's the first issue. The second issue is that people lose heart. So in other cases we have is people just simply abandon their cases and they say, I can't do this anymore. I can't keep traveling. I've moved provinces. Now you're subpoenaing me now. I'm not coming back. So people abandon their cases. And then, of course, if you look at the general message sent by long delays, is that it's the voices of these young victims are not being prioritized in the court space. Yes, we recognize there's delays with other cases, but, children should be afforded additional rights, as per Section 28 of our Constitution.
And when you, just to chat a bit more about the case you've just alluded to now, I know that you say that, of course, this is half their life and it's had an impact on them, but please take that further for us and just give us a sense in terms of the reliving the trauma and what that does to a child, especially if you have to go through a matter for 7 years.
All right, so let's start at the first issue. The first issue is you get subpoenaed to court. Now, for anybody to get subpoenaed to court, I mean, I do a fair amount of evidence in court. When I get subpoenaed to court, I get anxious. And it's not even about me because I'm giving evidence on behalf of other people. So it's just the court process in and of itself that causes anxiety. Then, as you say, you have to then be consulted with to, retell your version of what occurred to you, which of course is your trauma because it was committed to you. So you're sort of creating pathways again where that trauma runs down and you are reliving the trauma because you are remembering it. And as a result, you're going through those traumatic memories again. And you then have to come to the point where you've then got to stand up in court and you've got to say your version. Now, if there's a delay in that, you just repeat that process again. And if the delay is for something like, for example, the cameras aren't working, or the cleaner didn't bring the key, or there's load shedding, or there's no water, or the intermediary is sick, or whatever. The reality is that for that child, the message they get is what they have to say is not important. And it's the most important thing they will ever say in their lives, but it's treated as something that's unimportant. So there's the two issues. There's the reliving. So the first issue I said is just the general stress of court. And then the second issue is the reliving of the trauma that isn't deemed as important enough by the system to do something like bring a key to work. So it sends a very, very negative message to young victims and to their families, where they are saying, why should we enter the system that treats us in this way? And what that unfortunately does is it leads to a lower reporting rate, because people don't want to enter the system. And I hear time and time again, I don't want to go to the police, even though there's a mandatory reporting, because I'm scared of the secondary trauma that is going to be caused to my child by the system.
And in the cases that you've had to assist in the courts and even outside, how much of an impact as well does the DNA backlog also play when it comes to some of the delays that we see?
Well, I'll give you a practical example. So one of the impacts is that the cases get weakened by default. So in the one case I'm dealing with, you start off with 4 complainants with parents who are their children have all made statements and people have made statements. And then 7 years down the line, there's only 1 child remaining. Now, remember, a single child as a single witness in a sexual offence case, which is now considered historical or old because it happened so long ago, is a very complicated case to prove. So you are lowering your chances of gaining a conviction because everybody else has fallen out. In addition to that, the professionals that were involved, for example, the doctors who did the initial medicals may have been on, say, for example, registrar rotation as a pediatrician. They're now qualified and they've immigrated. Now, the medical evidence that would have corroborated the child's version of events is now the evidence is being given by somebody who didn't do the medical, which weakens that evidence because they didn't see that clinically. They testified on somebody else's report. So people just lose faith in the system. And it's a system that everybody's fighting so hard to uphold. And we've got some of the best laws and we've got some of the best policies. And, I'm in cases in the High Court where the system works flawlessly. So we know it can work. But when you come to the lower courts, there just seems to be this constant postponement of cases for the most arbitrary reasons. And people are saying, you're not taking me seriously, I'm not coming back.
And as a final one then briefly, Luke, where do they begin, to fix the system? What's that one thing that needs to get working urgently?
Well, I think for me it would be prioritising children's cases, because remember, a year in my life, I'm 55, a year in my life is nothing. If you're like one of my clients, you are 5. A year in your life is a sixth of your life. So think about children developmentally and act in their best interests.
Luke, thank you so much for your time. Appreciate it. That was the Head of Advocacy for Women and Men Against Child Abuse, Luke Lamprecht.